Welcome to this explainer from American Law Cafe. We're about to peel back the curtain on one of the legal world's biggest and kind of frustrating secrets. Not every lawsuit actually gets its day in court. Yeah, you heard that right. You could have a slam-dunk constitutional claim, a mountain of evidence, and still find the courthouse doors locked shut. So why is that? It's because the judiciary has this invisible velvet rope, a strict set of rules making sure only the right cases get in at the right time.
So why do courts turn people away? Well, it's not as arbitrary as it sounds. The Constitution itself actually limits federal courts to hearing real, live cases and controversies. They're not in the business of giving out advice or ruling on hypotheticals. So to get past that velvet rope, your case has to prove it belongs there. If it's too early, if it's too late, or if it's just plain not the court's fight to begin with, you're out of luck.
To get inside, every single case has to get past three major gatekeepers. First, there's ripeness. Are we jumping the gun? Is it too early? Second, mootness. Is the party already over? Is it too late? And finally, the political question doctrine. Is this even the court's fight to begin with? Okay, let's break them down.
All right, let's start with that first hurdle, ripeness. You can think of this doctrine as being all about timing. It's the court's way of hitting the brakes and asking, hey, is this lawsuit premature? Is the harm you're so worried about actually real? Or are you just scared of something that, well, might never even happen?
Essentially, ripeness stops courts from getting tangled up in these abstract what-if disagreements. Challenging a law before it's even been enforced, that's kind of like asking a movie critic to write a full review based only on the 2-minute trailer. It's just not going to work. The court needs to see the actual film, the real-world harm, before it can make a judgment.
Let's look at this in action, because it makes it way clearer. In Poe v. Ullman, there was this ancient Connecticut law on the books banning contraceptives, but nobody was enforcing it. The Supreme Court basically called the threat an empty shadow. The harm was totally hypothetical, so the case wasn't ripe. Now compare that to Abbott Labs. A new FDA rule was forcing drug companies to immediately spend a fortune changing all their labels or risk facing huge penalties. See the difference? The harm wasn't some future what-if. It was a real, expensive dilemma happening right then and there. That case was definitely ripe.
Okay, so let's say your case is ripe when you file it. You're not out of the woods yet, because it can still get tossed out later. And that brings us to our second gatekeeper, mootness. This one asks a different question. Even if there used to be a real fight here, is it already over? Has the ship sailed? To put it simply, if ripeness is about a lawsuit's birth, mootness is about its death. A case becomes moot when the main issue just disappears, and a court ruling wouldn't have any real practical effect. You know, it's like fighting tooth and nail over who should get a concert ticket after the concert has been canceled. You can argue all day, but a judge can't give you what you want anymore. The whole dispute is dead.
A classic example here is De Funis v. Odegaard. So this guy, Marco De Funis, sued the University of Washington Law School over its admissions policy. He actually got an injunction, which let him get into the school while the case proceeded. But these things take time. By the time his case crawled all the way up to the Supreme Court, he was already in his final quarter of law school. The school told the court, look, he's going to graduate no matter what you decide. So what could the court do for him? Absolutely nothing. The controversy had just vanished into thin air. His case was moot.
But, and this is a big but, some controversies are like zombies. They can come back from the dead. There are some really critical exceptions to mootness. For example, an issue might be capable of repetition, yet evading review. Think about election law challenges that are over before a court can ever rule. Or there's voluntary cessation, which means a defendant can't just stop their shady behavior to make a lawsuit disappear, only to start it up again later. Then you have continuing collateral consequences. Like, even after a prison sentence is served, a felony conviction can still cost you the right to vote. There are also exceptions for class action lawsuits, and some states, like Tennessee, even have a broad public interest exception for really important public issues.
So we've looked at cases that are too soon and cases that are too late. Now we get to the final, and honestly the trickiest, hurdle, the political question doctrine. This is where a court has a case that's ripe, it's not moot, but they still step back, throw up their hands, and say, you know what? This is not our fight to referee.
The big idea here is separation of powers. Some issues are explicitly handed over to Congress or the president by the Constitution's text. In other situations, there's just no clear legal rule for a judge to apply. This isn't about the courts trying to avoid controversy. It's about them recognizing the constitutional limits of their own power. It's them saying, that's not our job.
Two huge cases really show the difference. In Baker v. Carr, a challenge to voting districts was found to be justiciable, meaning the court could hear it.
Why? Because the Constitution didn't give that power exclusively to another branch, and the Equal Protection Clause gave the court a standard to apply. Now, contrast that with Nixon v. United States, and we're talking about an impeached judge here, not the president. He claimed the Senate didn't try his impeachment properly. But the Constitution gives the Senate the sole power to try impeachments. That's a clear textual commitment. Plus, what's the legal standard for a try? There isn't one. A court ruling could have caused total constitutional chaos. That, my friends, is a political question.
And you can see this logic playing out today. In Powell versus McCormick, the House of Representatives refused to seat a member who was duly elected and met all the qualifications. The court said, oh, we can hear this, because the Constitution lays out the exact qualifications for being a member. The House can judge those, but it can't just make up new ones. But then you get to Rucho v. Common Cause, which was a challenge to partisan gerrymandering. Here, the court punted. They declared it a political question because they couldn't find any manageable standard in the Constitution to decide how much political partisanship is too much.
So, after navigating that pretty complex legal maze, you can start to see that getting a case heard by a court is really like running a gauntlet. It has to survive 3 totally different challenges, and any one of them has the power to end the journey before you even get to argue the facts.
So really, it all boils down to a 3-question checklist. Number 1, is the harm real right now? Number 2, is the controversy still alive? And number 3, is this even a fight the courts are allowed to have? A lawsuit has to get a yes on all 3 of those to get past the velvet rope. These doctrines are there to make sure judicial power is used only as it was intended, to solve real, active disputes that are the proper business of the courts.
These rules draw a critical line in the sand between law and politics, but it does leave us with a really big lingering question. When courts dismiss a hugely important case, like partisan gerrymandering, by calling it a political question, are they correctly respecting the separation of powers? Or are they just avoiding their duty to protect our fundamental rights? That's a question that is still very much alive. For more legal deep dives from American Law Cafe, you can find us wherever you get your audio explainers.